Hi, I'm Shawn Bible, and today I'd like to go through with you just the basic timeline of a criminal case. How any criminal case starts is with an arrest. That arrest can occur usually by a police officer, although in the state of Georgia there is an additional mechanism by which you can be arrested called a civilian warrant. And that's where somebody goes to the magistrate court and they request that you be arrested. You usually have a pre-warrant hearing, so you will get notice of that before somebody knocks on your door and arrests you. But be aware of that. If you ever get notice of a pre-warrant hearing, you definitely want to talk to an attorney. It means you could be possibly arrested whether a police officer is involved or not. However, the main way, of course, that people are arrested is by a police officer. That can be because a police officer witnesses some kind of illegal activity, what he thinks is illegal activity, or after an investigation. The steps after that, after the initial investigation and the arrest, most people are arrested, and the next step, of course, is you want to get out of jail. You want to get out of jail before your trial date. On a lot of things, a bond is set automatically. A bond is an amount of money that you have to pay to the court, and it's a guarantee that you're going to return the court. There's two ways to make a bond. There's a property bond, which you put up a property. A lot of times you'll need property in the county or at least the state in which you were arrested. You can also use a bail bondsman, and bail bondsmen charge a fee, usually around 12%. You don't get that back. They may also ask for some collateral in addition to that, and they put up the remaining amount of your bond. If you don't show up to court, then they're responsible for paying the rest. Most bonds, like I said, are set automatically. For example, if you get charged with DUI or a misdemeanor of any kind, usually those are set automatically. Some felony cases, you have to see a magistrate judge. Usually that will occur within 72 hours, and he'll set a bond for you. In very serious criminal cases, some child molestation cases, armed robbery, murder, the most serious of felony offenses, you'll not get a bond set automatically. You'll actually have to have an attorney usually file a motion for a bond, and you'll at least have to go in front of a superior court judge and have a bond set. And in some cases, that bond can be denied for quite a while. Once you make bond, your case will be set for trial. Usually the first step is what's called an arraignment. The arraignment process works differently and at different times depending on which court you're going to. And the circuit that I practice in the Lookout Mountain Judicial Circuit, an arraignment usually occurs in Superior Court sometimes several months after an arrest. It's very important if you get arrested that you make sure that the court, that your bondsman, that everybody knows what your address is so you don't miss court. If you miss court, the judge will issue a warrant for your arrest and you'll be brought to court by force. So make sure you don't miss that. Sometimes those notices are sent out pretty late notice. You may only have a few days. So you need to, if you don't have an attorney, especially be aware of those court dates, those arraignment dates. If you have an attorney should help you be there and should inform you of your date. When you go to arraignment, you'll have to plead guilty or not guilty. If you plead guilty, your case is over at that point, you'll be sentenced. If you plead not guilty, and usually that plea can be changed if you after negotiations. If you plead not guilty, there's some things that have to be done within 10 days of arraignment. Certain motions have to be filed. You'll need an attorney to do that, or you should hire an attorney to do that. At some point after that, you'll have your trial date. Usually before the trial date, there'll be negotiations with the prosecuting attorney, the DA, or the solicitor. Most criminal cases are resolved that way. The ones that aren't go to trial. Sometimes you'll have pre-trial motions, which is hearings in front of the judge before trial. In other cases, you'll go directly to trial. If it's a misdemeanor case, usually that trial will occur usually within the year after you're arrested, if not sooner. If it's a felony case, it may take longer, depending on how many witnesses and how many pretrial motions are going to be heard. But at the end of the day, almost all criminal cases are resolved either by agreement or by trial. If your case is resolved by agreement, your attorney will work out a plea offer in advance with the district attorney or the solicitor, and then that will be announced in front of the judge, and that will be the end of your case. If you go to trial, then the jury will decide your guilt or innocence if you have a jury trial, but the judge will decide what your sentence will be. At that point, if you win, you walk out of the courtroom and it's like nothing ever happened. If you lose, the judge will then sentence you, and you could be incarcerated or you can go on probation. That's usually the two things that can happen, and usually have a combination of both. That's a basic overview of the timeline of a criminal case. Again, that process can vary from, in a city court, a municipal court, from a couple of months to a serious felony case. That process can be stretched over several years if it's a serious felony case. Thank you for watching this, and if you are charged with a criminal offense, especially a serious criminal offense, you really do need to contact an attorney. Feel free to call our office for a free consultation. We don't charge anything for the initial consultation on criminal cases. If you don't call us, please at least call an attorney if you're charged with a serious crime. Thank you.